Consideration is a fundamental element of contract law that ensures a mutual exchange of value between the parties involved in a contract. It distinguishes enforceable agreements from mere promises and is essential for the formation of a legally binding contract. Definition of consideration (EA). Basic definition. Consideration. Consideration refers to something of value that is exchanged between the parties in a contract. It can be a promise to do something, a promise to refrain from doing something, or the actual performance of an act. It serves as the inducement for entering into the agreement. Key principles of consideration. 1. Value requirement. Value. Consideration must have some value in the eyes of the law, though it does not have to be equal in value to the benefit received. This means that the law is more concerned with the presence of consideration rather than its adequacy. 2. Mutuality, reciprocity. Both parties to the contract must provide consideration, creating a reciprocal exchange. Each party must both give and receive something of value. Types of consideration. 1. Executory consideration. Future promise. Executory consideration involves a promise to perform an act or provide something of value in the future. Example. A contractor promises to build a house in exchange for a payment of $50,000 to be made upon completion. 2. Executed consideration. Immediate performance. Executed consideration involves the performance of an act or providing something of value at the time the contract is made. Example. A buyer pays for a car in cash, and the seller immediately transfers ownership of the car to the buyer. 3. Past consideration. Previous act. Past consideration refers to an act or benefit provided before the agreement was made. Generally, past consideration is not sufficient to form a binding contract unless it was provided at the request of the promisor. Example. If someone helps you move your furniture as a favor, and you later promise to pay them for their help, the assistance given previously cannot be considered valid consideration for the new promise. Rules and requirements of consideration. 1. Adequacy of consideration court's perspective. The law does not require consideration to be adequate or equivalent in value to the benefit received. The disparity in value will not invalidate a contract as long as some consideration exists. Freedom of contract. Parties are free to negotiate and agree upon the terms and value of consideration without interference from the court. 2. Sufficiency of consideration. Legal value. Consideration must be sufficient, meaning it must be something of legal value. This can include money, goods, services, or a promise to perform or refrain from performing a particular action. Nominal consideration. A minimal amount of consideration, e.g., 1, can be deemed sufficient if it is intended to create a binding agreement. 3. Forbearance as consideration. Refraining from action. A promise to refrain from doing something, forbearance, can constitute valid consideration. Example. Agreeing not to sue someone in exchange for a settlement payment is valid consideration. 4. Pre-existing duty rule. Pre-existing obligations. Performing a pre-existing legal duty or contractual obligation cannot be considered valid consideration for a new promise, as no new benefit is provided. Exceptions. If additional duties or benefits are provided beyond the pre-existing obligation, this can constitute valid consideration. 5. Part payment of debt. General rule. Part payment of an existing debt is not valid consideration for a promise to discharge the remaining debt, as no new consideration is provided. Exceptions. This rule can be circumvented if additional consideration is provided, e.g., early payment, payment in a different form, or a different location. Legal exceptions to consideration. 1. Promissory estoppel. Reliance on promise. Promissory estoppel allows a promise to be enforced without consideration, if the promisee reasonably relied on the promise to their detriment. Elements. There must be a clear promise, reliance by the promisee, detriment suffered due to reliance, and it must be unconscionable to allow the promiser to renege on the promise. 2. Agreements made under seal, deeds. Formal requirements. Contracts executed as deeds, under seal, do not require consideration to be legally binding. These agreements typically involve formal documentation and witnessing,